Good morning, everyone, and welcome to the first panel of today's summit, celebrating 20 years of the EDPS. I am Daniele Nardi. I am the Legal Service Officer of the EDPS. I have the privilege and the honor to moderate the first panel. Today's first panel has a very nice, I would say, stellar roster of panelists. I'm very glad that they accepted our invitation. And without further ado, I will present them. They have the task of introducing this day, and therefore we will ask general questions about data protection, but I wouldn't want to call them necessarily general. I would prefer, and that's what I said to the panelists when we briefly discussed in advance of this panel, that we're going to try to be a bit philosophical, which is, of course, a danger. But the idea is really to open up this summit with some reflection on why really we have data protection. So to discuss this, I have first from my left, Professor Linsky, Orla. Orla is Associate Professor at the London School of Economics. She is visiting professor at the College of Europe in Bruges, and she published extensively on data protection matters, but also on technology regulation issues. And I noticed that in 2015, you wrote a book that goes by the title, The Foundations of EU Data Protection Law. And although some time has passed, I could not avoid but mentioning such your contribution. And now you are more inquiring into the complete and effective nature of data protection law. You are a joint editor-in-chief for the International Data Privacy Law, and you contribute to several publications. Thanks for being with us. Next, we have Madam Vice President Vera Jourova, Vice President of the Commission in charge of values and transparency. As you know, as we all know, in her portfolio, there is also democracy, rule of law, media pluralism, and the fight against misinformation. Under the previous mandate of the Commission, Madam Vice President served as Commissioner for Justice, Consumers, and Gender Equality, and thank you for honoring us with your presence. Next, we have Gary Davis. Gary is Global Senior Director for Privacy and Law Enforcement at Apple. Before being Apple's man on privacy and data protection, he also worked in the Irish Data Protection Commission and in the Irish Prime Minister's Office. Thank you for being with us, Gary. And remaining in this Irish trend, we have Commissioner Des Hogan. Welcome. Des Hogan is Commissioner for Data Protection, but he's also the current chairman of the Irish Data Protection Commission since February this year. He was appointed after having been in the past Chief State Solicitor, and you also worked as Chief Executive in the Irish Human Rights Commission. So you have a background which is very relevant and useful for this panel. Thanks for being here. And finally, we have Advocate General Henrik Saugmannsgaard-Ö, and little disclaimer, he trained me on how to pronounce his family name. So I should have got it almost right. Henrik is partner as Gorrissen Federspiel in Copenhagen, and as I said, he has previously served as Advocate General at the European Court of Justice, and as this audience knows, he was involved in very many important data protection cases. Probably this is even an understatement. Thanks to my panelists. Without further ado, we are conveniently late, but not even too much. My aim is to leave time for some question and answers at the end. I will ask my panelists, despite the philosophical nature of this panel, to contain their intervention to 3-4 minutes, but I will not be too tyrannic, hopefully, but in case I can be. And without further ado, let's start with Orla, Professor Linsky. Let's start with you as representative of academia. So, behind the protection of every fundamental right lies a struggle against power, or to put it perhaps more mildly, the aspiration to protect people against abuses of power. And traditionally, individuals needed to be protected against the power of the state. But if there is a field where there is a need for protection, not just from the power of the state, but also from powerful private actors, this field is the protection of personal data. But having said that, maybe it would be useful to start this panel, to start the discussion today with a reflection on what really lies at the root of data protection. And perhaps to answer this question, we need to go to a famous debate, perhaps, at least in the circle of connoisseurs. But what is data protection protecting that privacy is not? Thank you. Over to you.
Thank you, Daniele. And if I might begin just by saying thank you for the invitation to participate today. And I say this because the Office of the European Data Protection Supervisor, past and present, has always been so supportive of academic research and so engaged with academic research. And I think you could already get a glimpse this morning from the opening remarks that there's still an academic spirit beneath the European Data Protection Supervisor's office. And on this question also, the work of the European Data Protection Supervisor, I think, has helped to advance our understanding of the meaning of the rights to data protection and the right to respect for private life. So going to your question as to what is the root of the right to data protection, I would say that this is fundamentally about power. So data protection recognises that control over data processing and control over data processing operations can itself be a source of power, whether that is done by the private sector or whether that is done by the public sector. And that control over data processing operations can be used clearly for societal benefits, but it can also be used in a way that leads to various information-induced harms across a wide range of fundamental rights. And so what the right to data protection does is to impose a kind of structure or a rigor on data processing operations in order to mitigate against those data-induced or information-induced harms. And so it does this, as I had investigated in earlier work, through giving individuals rights in relation to personal information, but as a lot of the scholarly literature has observed since, the idea of individual control over personal data is not in itself going to act as an effective mitigator against this power. So it also imposes principles on personal data processing. So those kind of principles like fairness, purpose limitation, data minimization, and also at the end of data processing processes, an effective oversight system. So I would say at its root, we are talking about a structure that tries to mitigate the impact of data as power. And then how is this different from what we see in terms of the right to respect for private life? Well, here I think our understanding of this question is really advancing in recent years. And I think you can start to see this distinction play out more and more in practice. So I would say that data protection and privacy are heavily overlapping rights, and that they could be brought even closer through a very liberal interpretation of the right to privacy. However, at the moment, you could say there's an institutional dimension to data protection. So the fact that the right to data protection requires independent oversight, which is absent from the right to respect for private life. And we're seeing that in the UK, for example, where legislation was proposed that would significantly hinder the independence of the regulator, and that was because of the absence of a right to data protection, I would say. But also very substantively, data protection gives us more rights in relation to more information than privacy. And a really good example of this is the right to respect for private life applies to information in which we have a reasonable expectation of privacy. But we avoid going down that rabbit hole of what is a reasonable expectation of privacy in data protection, which allows us to extend the data protection framework to things like data scraping on the internet, where even though the information is publicly available, we can still consider that the way in which that information is used might lead to information-induced harms. So I think this distinction is really starting to come of age now.
Thank you, Orla. I think it's really, what struck me is your reference to the institutional side of it. And in a way, institutionalizing the protections and enshrining them in the GDPR has been one of the effective ways in which individuals could finally be protected. And this allowed me to really move to you, Madam Vice President, because you have been at the center of really important years for data protection. Under your watch, the GDPR, which is this tool that gives the possibility for individuals to protect themselves against various forms of powers. And as we heard, it really empowers them to do so. Well, this tool has been adopted, as I said, during your tenures. So I know that you will not be seeking another mandate. So I wanted to ask you, following what we just heard, what would you advise your successor to watch out? What would be the key message? And more generally, after 10 years, have your views evolved on the need and on the usefulness of data protection rules?
Okay, thank you very much. Good morning. You mentioned that I'm finishing in the commission. There will be the day after, and I'm happy I got the advice from Mr. Vievorovsky, who said that he is academic and lawyer. I will become academic and lawyer after the 1st of January. Your advice was to organize a conference. Happy to know what I will be doing in January next year. But indeed, I will be really carefully watching who will be the successor, because I have on my table not only the protection of fundamental rights, which include privacy, but also rule of law, protection of democracy, protection of people against abuse online, and you can do this by different ways. There is no one recipe or advice how to do it. I would warn against doing it from the technological point of view. So I will be watching who will be doing the job. In my view, it should not be a technologist who will know into details the things connected with the protection of privacy. Because I think that as a regulator, as a legislator and politician, you have to zoom out a little bit and see, especially this philosophical and societal aspect. Neither technologist nor activist or even fanatic, because of course working in the field of data protection, you simply have to also listen to those who speak about economy and security, because it's a triangle. Privacy as an individual right, economy which requires trust of consumers, but still economy is a big factor, and security. I think that my follower will do the job in the time of increased demand of the society on security. We live in a kind of, I don't want to say dangerous time, but nervous time, when we have to get used to different new kinds of risks and threats. And in such period of time, the people always want the state to be stronger, and people who want to be more secure, that's why they ask the state to guarantee that. So then, of course, we might see bigger pressure from the states to be able to get into the private data of people. So, in other words, the pendula between individual rights, protection of privacy, and security, which means stronger state, might have a tendency to go more to the side of the strong state. I don't wish so, but I just see the societal atmosphere. So my follower will have to be strong and be able to defend the individual rights of people. What was the second question?
The second question is about data protection and...
My God, this is all about data protection.
Yes, indeed.
Help
indeed.
me more.
It's not about AI, strangely. Although, no, the question was more whether your views have evolved in those 10 years, whether there is something that has changed in how you approach data protection.
Yeah, well, this shouldn't be a discussion about GDPR, but I have to speak about GDPR, replying on this question, because GDPR was a lonely sheriff in the place of in the field of digital regulation. Several years alone, and then we started to regulate further things: Data Act, Data Governance Act, Digital Services Act, Digital Markets Act, Health Data Safety, plus the jewel on the crown, the AI Act. I was working on all of that. And always I was the one who was saying, let's calm down. We have the basic pillar. We have the GDPR. We have the data of people well protected in the EU. So we can build everything else around that. So GDPR served as a central pillar, center point. Some of my colleagues say it's more construction side, so choose whether you are verticals or horizontals. But GDPR played absolutely essential role, and everything what came later was complementing and building on GDPR, because GDPR is first of all basic principle that the privacy of people is fundamental right, which is in all constitutions of our member states, and which deserves the highest level of protection.
Thank you very much. Gary, I would like to move to you. We've heard Madam Vice President indicating the particular crossroad we are at in these days, where there is an increased demand for security. And I know that Apple has always placed emphasis on data protection. It has clearly become a great branding strategy, and perhaps it's also very suited to Apple's original and originary business model. So one of the questions of this panel is, why do we need data protection? Why do companies need data protection? And maybe a follow-up to this question is, I know that Apple has recently announced the launch of Apple Intelligence, and it has maintained its focus on in-device processing, but with some exception, in particular whenever the artificial intelligence task cannot be processed in the device. I was wondering whether this will change somehow the way in which Apple deals with data protection, and how Apple also, I know that, resists to when those demands for including security are becoming more and more pressing. If you can develop on this, so why do companies need data protection first?
I might need more than 4 minutes to answer all of that, but
I'll give you 4:30.
okay. And I might hopefully come back to the second question, which I've heard called the pendulum. I also, Wojciech spoke about it in a lot of detail as well, in terms of the need to balance the interest from a state perspective and an individual data protection perspective. And I would like to say a lot more about that shortly. But first of all, thank you very much, Danielle and Wojciech and team, for inviting me along. It is a true privilege for me to be even say a few words at such an event. Those of you who know me will know that I had a close personal relationship with Giovanni that went back to 2006, when I first became the Deputy Commissioner in Ireland. Giovanni was a huge personal influence on me. I miss him, and I know that he is smiling down upon us today. And I know he will be mentioned many other times. Those of you who know that will also know that Giovanni also had a huge influence on Apple's CEO, Tim Cook. They met many times, not publicly often. Tim was listening to Giovanni's words in guiding Apple as to how we think about privacy. Not as a branding strategy, I shall be very clear. The feelings are very strong in terms of how we wish to put users at the center of how they manage their data. And Tim actually would have wanted to be here today, and actually we tried quite hard to see if we could make it work. But unfortunately for you, you're stuck with me as a result. So I will try and do a little bit of justice to that. In terms of the announcements that we made just last week on Gen AI, yes, you're absolutely correct, Danielle. We've had to think about how do we offer a compelling Gen AI experience for our users while remaining true to our North Star, which is privacy. And yes, we have had a huge focus on on-device processing, because our view is if the processing is taking place on the device, well then it is far more likely that the data will be protected and that it will not be used in a way that is surprising for a user. It also so happens that when you can do something on device, you will actually likely get a more powerful, no latency kind of experience. So it works well both from a privacy and a customer experience perspective. But Gen AI obviously has some huge processing requirements associated with it, all of which cannot be met on device. So I think the simple thing to do would have been to go, cool, let's just move it all to the server and do it there. And you know, we'll just explain to users that there's some trade-offs involved here. But that's not who we are as Apple. We would not offer our Apple Intelligence offerings if we were not able to extend the protections which we have for users on the device to what we are doing in the cloud. So in fact, we are offering something that's called, I don't want this to be marketing in any way, but I think it's kind of beneficial to just talk about the principles. We're offering something that we're calling private cloud compute, which is a way in which the request from the user will be computed in some cases in the cloud, but always in a way whereby the request is fulfilled and then no record of it will be retained. Apple will not be able to look at the request or retain any record of it. And then crucially, because obviously, you know, there's a big request there that we trust, that people trust us, we will be providing for verifiable transparency associated with it. So security researchers will have access to how it is taking place. That's a very important step. And the reason we're doing that is, I think, a principle that will likely, I think, overlay the whole day, which is that without trust from individuals that their data is going to be protected, they will not use services. They will not use Apple services. They will be careful about using other services. They will not trust the state, which is something that Madam Vice President spoke about there, maybe not in those precise terms, but I think it's something that overlays our conversation. And so I feel as we think about what are we protecting here, we are protecting trust so that individuals can in fact participate in a way that they have confidence. If they don't have that confidence, then they will start to draw back, and everybody loses in a situation where individuals cannot trust either the companies that they're engaging with or the state that they're engaging with. Thank you very much.
Thank you, Gary. Trust. I think it's, indeed, you're right. I think it's a key word that might certainly come back in the discussions today. And it allows me to move to our panelist, who's an enforcer, Commissioner Hogan. You are sitting on an important chair for enforcement of data protection, and you're certainly not new to matters related to fundamental rights, but perhaps we can say you're relatively new, if you forgive your moderator, to data protection matters. But this actually makes your presence in this panel, I think, even more valuable, because you can give really your view with the benefit, so to say, of the newcomer. And I would like you the floor, to leave you the floor to give your general answer to the question, what is data protection protecting, which is the topic of this panel, but maybe surfing on what Gary said, enforcement indeed comes after that form of trust has been somehow betrayed, and it's up to you to find out that there's been this betrayal. And sometimes, and here I'm a bit more negative than Gary, sometimes I think people are more interested by the shiny new technological novelty. Everyone likes innovation, and they might, forgive me if I'm a bit paternalistic, perhaps they might forget a bit protection of personal data. But I stand to be contradicted, of course, if you want so. The floor is yours.
Thank you. Thank you, Daniel. And I suppose you're right. Today is 4 months since I took up office with my fellow Commissioner Dale Sutherland in the Irish Commission. And I think just at the start to congratulate Wojciech and EDPBS. In the European Data Protection Board, we very much respect and support the work of our colleagues in the EDPBS. So again, congratulations today and thank you for the invitation. Your question is, what is data protection protecting? For me, I go back to the Article 1 of the Universal Declaration of Human Rights. All human beings are born free and equal in dignity and rights. So it starts with values, it starts with principles. And then the question goes to what, again, as Orla said, the regulators, because it is very part of the picture in the Charter. There are independent authorities in each state, and our role is to ensure the protection of the rights in the GDPR and in the Charter. And we're very busy. There are an awful lot on our plates. There's a lot coming at us, and we have individual complaints which we must deal with. We also have, I suppose, we have more systemic areas which we look at. So it's a question of looking at what is the greatest risk, and how we can address those risks. So I suppose in the Irish Commission, if you look at some of the work we have done, we had a focus in our regulatory strategy, which is still ongoing, into children's rights. So in the Instagram and TikTok inquiries, that was looking at those questions about, public by default. And of course, the risk, what is the risk to children, risk of exploitation, risk of abuse, risk of data theft, risk of identity theft. And this brings me back again, before I go on to those inquiries, into data protection is about identity. 6 years on from the GDPR, coming into this area from outside, it strikes me that the world is different. It's only 6 years, but the world is different. If we look at younger people, we look at how they interact with with technology, with their phones. Not only are they spending more time on their phones, they're spending more of their personality on their phones or on their devices. They're spending more of their future on their phones and on their devices. So this is something societal which challenges us. The Universal Declaration of Human Rights looked at power, as Orla said, that was coming from the state. And now in the GDPR, we have the state and we have the non-state actors as well, which brings with us challenges. So those inquiries, just to come back to those, what was the risk? It was the risk to those rights of children. So they resulted in infringements with our common regulators with the consistency mechanism in cooperation in the GDPR. And we imposed corrective measures. So there was, I think, 740 million in fines. But the fines are not the end of the story, because the more important for me is the corrective measures. So in both those cases, there were a number of corrective measures which were directed to the controllers, and it was to fix the problem, so you will not have the harm continuing into the future. And so I'm happy to say, I think, Dale, we can say that we're coming to the close of those corrective measures with those two controllers, where we are satisfied with the measures they have taken to address those corrective measures. I should say that there is litigation, but I suppose the pleasing thing, notwithstanding the court cases, is the fact that the companies have engaged in terms of fixing the problem. Because again, what is data protection protecting? We have to make sure it's not just protecting the rights which were being surfaced 6 years ago. We have to think about today and we have to think about tomorrow. So, but it is an open question. It is a question for us regulators. What are we protecting? Are we doing, what are we doing, and are we doing it in the right areas? It is an open question. It is something which we continue need to challenge ourselves and be challenged by civil society and by, you know, by our by the controllers, by society. Yeah.
Thanks a lot. I was particularly struck by your reference to data protection also as a tool to protect identity, and you made several examples, and I think that's very topical because it goes at the core of the self-standing nature and essence of the right. But I would say that in legal terms, and I turn now to the Advocate General that we have among us, Eric, yes, of course, data protection has this inner core, this mission that enables protection of identity and ultimately protection of freedom against power, as we started this panel. We started this panel with this reflection. But can't we see it actually also as a gateway right? So a right that enables other rights to be protected and enforced. Maybe this aspect has grown in importance in the last years. Would you agree with this? Or should we focus the discussion in general on the autonomy of data protection, for example, in relation to privacy? Or should we instead look at data protection also as an enabler of other rights?
Thank you very much, and good morning to all of you. And big congratulations to the EDPS for its 20th anniversary. It's, in my opinion, a hugely important institution that we have in the EU. Data protection is fundamental in a democratic society. I looked up on your website this morning, and you have 5 reasons to respect it. First of all, that's obvious. It's a fundamental right protected by law in the Charter. It helps to build trust. It's already been mentioned. And it also prevents fraud and cybercrimes. If we look at the Charter, it's striking, and I had the privilege back in 2000 to help the representative, the Danish Prime Minister, in negotiating the Charter. It's quite striking that it has its own provision, because if you compare it with the Human Rights Convention, you have an article on private life, but in the Charter you both have an article on private life and data protection. So there is a huge emphasis on that fundamental right. We can go all the way back to the Greek philosophers. Aristotle told us that we need to distinguish between oikos, the private family life, and polis, the scene where you are in the public. And the protection of your private life has, throughout history, been extremely important. I must say, when I had the privilege of being Advocate General in the Tele2 Watson case, it was a real eye-opener for me. There, of course, it was a balancing of fundamental rights. And I will come back to what Madam Vice President said, the strong state that we need in times of insecurity. There is also an Article 6 in the Charter that gives people the right to have security. And that is, of course, invoked by member states in order to combat, for example, terrorist attacks. And we've seen it in the French terrorist attacks that there were a huge demand for that kind of information to find the perpetrators. So you have on one side Article 6 and on the other side Article 7 and 8, and you need to balance them against each other. That's what the court did in that decision. And it is a very, very difficult task because the information you can get from data retention schemes are quite important. I mean, imagine people, why do you need to phone a defense lawyer? Why do you need a divorce lawyer? Why do you have to talk to a psychologist because you sent him an SMS? Where were you last night? You can see the exact location. So these reveals of private lives is quite important. And I was struggled, must say, by that case. And then I remember very clearly because I was not completely followed by the court in it. My appreciation was that the national laws in Sweden and the UK were to some extent correct. There was a balancing of the need for security against the right to private life and the safeguards for that. The court went a little stronger and said, well, put more emphasis on Article 7 and 8 in its judgment. And if you remember the famous German movie Das Leben der anderen, the lives of the others, if you had the technology means that we have today and put them into that film, you kind of get the idea of what the court is looking at here. So a more strong protection of private life and data protection. And I must admit here in full openness that I tend to agree with that judgment now after a couple of years. That has been revised a little bit, and we also had in Quattro du Net and most recently in a case by the full court, where it has been moderated slightly. We've seen it also with the Schrems 2 case, where I was also Advocate General on the data transfer to the US. There it is another balance that we need to have, and that's an economic one. The possibility to do trade with the US and at the same time accepting a certain risk to exposure of personal data in third countries. Also extremely difficult task where we need to weigh up against each other the interest. And the interests are not small here. We are talking about, and we were informed at the court, we're talking about up to 4% of the gross national product in Europe if we could not do trade with the US. And it would be a paradox if it would be more difficult to trade with the US, our closest ally, than, for example, with India and China, where we have more, because we have more information about the American surveillance programs that we do of the Indian and the Chinese. So there's a lot of very, very interesting question that comes up here. And I can say to you, it is by far the easiest task that the court have had to deal with, and also for me personally. So I look forward to today's discussions on these extremely interesting topics. Thank you.
Thank you. Now, since it's not every day that I can be the one asking questions to an Advocate General, I would like to continue with you and surfing on what you just said. Well, this panel aims to discuss, as we said, basic questions. And while I was listening to you and thinking about the data retention line of case law, coming back a bit to this panel and joining the two reflections, I was thinking, has not data protection become a bit too complicated in practice? Or perhaps this is normal. For example, if we have to let law enforcement authorities do their job and prosecute crime and satisfy the demand of security, which, as you suggested, is also enshrined in the Charter in Article 6, they need the tool to do that. But, you know, to strike that balance, the court seemed to have gone into very many levels of details. I liked your comparison with le goût des autres, or the taste of others. I don't dare to pronounce it in German. What's your feeling about this? Is there, for data protection to achieve its aim, is it the case law becoming too complicated, or is this inevitable if we want to strike this balance between security, for example, and the protection of the right of persons?
It is certainly extremely complicated. Just to recall slightly, I mean, the court said in Tele 2, Sverige, that you can only have a targeted retention scheme, not a general one, because you cannot put the full population under surveillance just to combat crimes, and it can only be used for serious crimes. Now, in the quadrature that was nuanced a little bit, so you can have a general retention scheme if it is to protect national security, for example, the threat of terrorism. And most recently, in the quadrature from April, in the full court. And full court is all the judges, so it's all 27 judges sitting on the bench. That is very rare that happens. That was to nuance the case law a little bit, so now it can also, this information can be used to combat less serious crime, for example, copyright infringements on the internet, because that's the only proof that you have is that kind of data. That in itself is complicated, but I would also just say the Schrems 2 judgment I've had to, as a lawyer, to look at a few times after I left the court, is in itself striking, because the court accepts, by accepting the validity of the standard clauses, in my opinion, accepts an inherent risk. So if you have standard clauses to trade with, I'm not talking about the US now, but other third countries, with these extra safeguards, you are actually accepting there's a risk in doing that. And I think we need to live with that risk. So we should maintain a high protection, but accept we have to balance it and live with some sort of risk, because we do need to trade with the outside world. But I admit it is extremely complicated, but today's life has also become quite complicated.
Thank you. Gary, I think you wanted to say something more about, law enforcement, access by law enforcement authorities, and this delicate balancing that we just discussed with reference to the case law of the court. Is that so, or am I wrong?
No, I'm always happy to talk about that. In fact, I was briefly, yes, I will certainly do it. I also wanted to just, I guess, broaden it out a little bit more. Certainly on the law enforcement side, Apple has been at the forefront of, I guess, taking positions on that. What we've seen, I guess, over many years is trying to find that balance for states having access to data and individuals having an ability to feel that it's protected. From Apple's perspective, we've obviously championed end-to-end encryption. We have a particular view in relation to end-to-end encryption, whether it's on the device, whether it's on some of our communication services, whether it's now the cloud. But that's something which has continuously faced questions. So we've seen in the last year a question as to how can we meet our GDPR obligations, let's call them, to protect data and the fundamental right that people have, we would feel, for their data to be protected while it's with Apple and elsewhere. There's a question now, if I look at the update in the UK, for instance, to the Investigatory Powers Act, which would now require companies like Apple, who are providing services into the UK, to check with the Home Office before we make a security update that could remove data which the law enforcement authorities have access today from their ability to make a request for it in the future. What that effectively means is that our ability to continue on the path that we have been on over many years, which is to ever more reduce the surface area of data that we have access to for good security reasons, because we all know that when companies have data, some attacker or other party will seek to get their hands on it, that now will be subject to review by Home Office authorities in the UK if we make those updates anywhere in the world. Not just if we make them in the UK, but if we make them anywhere in the world. So we as Apple spoke out quite strongly, actually, on that issue, but the law passed, so we will see in due course how that plays out. But I do think it's very important, before we get too complacent here and feel too comfortable in our seats. We see very similar patterns now playing out here in Europe, which I think has been the subject of the conversation. We do face requests right now from authorities in Europe to retain data associated with your use of iMessage and FaceTime. We face requests for interception of those services. That's happening now. We face, just last week, the high-level group on access to data for law enforcement purposes published 42 recommendations on how to better work together. Most of those recommendations are good. I would actually recommend them, those recommendations about how law enforcement authorities should work together, share information, cooperate, make sure that they have a great understanding of what's happening. But contained within there is the exact same issue we've all been hearing for many years, which is that there should be a, let's call it a backdoor, in certain situations into certain services. And we all know, I believe in this room, that there can be no such backdoor which does not compromise the security of every service user. And so from my point of view, in that, Apple speaks about it. I'm speaking about it today. I hear civil society speaking about it. I would encourage you all to read Edry's excellent blog post on the report of the high-level working group. But actually, I'm kind of disappointed. I don't often hear the voices of the EU data protection authorities on some issues. I see Commissioner Kelber here in front of me. I hear his voice on encryption. I certainly hear the EDPS often, but I think there is a very important voice which has been missing, and that is data protection authorities, who perhaps sometimes are more driven by the need to focus on enforcement issues, not actually taking strong public positions on something which is extremely important for this community, which is how do we feel about that balance to be struck. And there's been other areas. We've launched app tracking transparency a few years ago, really designed to protect data so that it wouldn't be used for advertising purposes. Again, we heard from some people, we did not hear from others. And the issue is that when your voices are not heard, you leave the stage to other voices who have other interests, in that particular instance, advertisers who have been making their voices known. And that's something which I'd hope through forums like this, that people will think about where can their voices be heard and be influential, because they will need to be heard. As Madam President, Vice President indicated, the pendulum is swinging, and we should be very aware of how it's swinging. Thank you.
Thank you. I know that there are reactions in the panel. Please, Madam Vice President.
You see, less and less we need your questions, but I think it should be like that we react on each other. First, what Gary just said about the recommendation. Well, it was interesting last week because we had Justice and Home Affairs Council. Home Affairs was first, Ministers of Home Affairs, so the Masters of Security. Then the second day, it was Justice. It was also with my participation, where, if I simplify, there were more the people who should protect privacy. Yeah, so those two worlds, and I realized how much it is true that we go through permanent rebalancing of those powers and those two principles, Article 6 and 7. Because what the Home Affairs side proposed in the recommendation, it was something I had to react the next day by saying, wait a minute, it's recommendation, okay, there are good things, but if we would speak about hard law, we would really have to think over whether the balance is there, yeah? So it was rebalancing in practice. I don't want to say that you don't have to follow all the recommendations. I just want to say that the protection of privacy is still there. Another example, e-evidence regulation. It was parked in the parliament for years. And I was promoting this because we needed swifter access to data, to evidence on serious crimes, swifter cross-border exchange. It was sparked because there was an argument of fundamental rights. But the right of security is also a fundamental right. Yeah. So I just saw in the parliament that yes, the Libe committee, where there are very devoted people for privacy, is not balanced by maybe equally strong committee which would cover the security things. It's also maybe something which we will see changing. So e-evidence has I know.
No, it's fine. Go ahead.
90 seconds.
No, more. 3.
2 minutes.
Yes, go ahead.
Evidence is important for our cooperation with the United States because under their Cloud Act, they have a possibility to take the data from Europe. We need the same thing. We need the reciprocity. I will finish with 2 things. AI Act, if you read it, it's very precisely balanced. The access to data from law enforcement side was very precisely formulated because we believe that the technology can be of big help for fight against serious crime. But it must have limits because privacy of people is at stake. And last, and it's the painful story, the protection of children against sexual abuse. Now, as we speak, the ambassadors speak about that because the Commission proposed, yes, let's propose the method or the rule that even encrypted messaging can be broken for the sake of better protection of children. And it was the most horrible moment in what I experienced in this dilemma between security and privacy, because with bleeding heart, as somebody who is protecting privacy, I had to say, well, the abuse of children online is so horrific and the statistics is so terrible that we have to do more for the children. These dilemmas will continue.
Thank you. If this panel had to be a bit of an hors d'oeuvre for the day, now with your intervention, Madam Vice President, we have a whole buffet to choose from, and luckily we have many other panels where I think the topics so
I
crucial.
hope I'm not the only one on the menu.
No, thanks. Orla, do you want to react? What are your thoughts? And then I can't see my time manager, which is good because I would leave still time for a couple of questions. 1 question, half a question. Go ahead in the meantime, Orla.
Okay, maybe if I just pick up on 2 points then that have been made so far. So the first around backdoors to encryption. So I might have a slightly different take on Apple's ATT than Gary, but on backdoors to encryption, I do think bringing this back to the right to data protection, there will be an interesting question there about whether or not you could say that those kind of legislation that mandates a backdoor to encryption respects the essence of the right to data protection in terms of ensuring appropriate security and organizational measures. And I do think this is one area where we could possibly test what has been largely an academic issue so far around the essence of rights. The second thing then, just kind of stepping back from the kind of data retention saga as we've seen it so far, I do think it's necessary to query to what extent in Europe we want to normalise general surveillance of entire populations in the absence of a serious crime, for example. So I think when you start to pose the counterfactual, you get to the court's kind of starting point from Digital Rights Ireland onwards. And then what we've seen since, I think, is very much a product of the fact that the right to data protection in Europe, and I would say the EU as a fundamental rights actor as a whole, is very much constrained by the competences of the EU and by its legal and institutional context. That the court here has been dealing with the right, which is defined in part through legislation. And so it's had to take into account institutional balance with the other European institutions, but also an attempt to avoid, I would say, a constitutional crisis with the member states, constitutional courts and national legislatures. And so this is, I think, almost coming close to a negotiated settlement in this area to try to get to an appropriate balance that respects fundamental rights in this area.
Thank you. So, I see people coming, but who has the question? Please. If you can introduce yourself, thanks a lot.
Hello, my name is Johnny Ryan. I work for a civil rights organization, but I spent some time in industry. It's a question for Madame Jourova, and it's a question really in your thinking about your successor. There appear to me to be many domains where there isn't a balance between data protection and security, but more a complementarity. And it feels that that's unexploited at the moment. Let me give you an example. We have, I'm Irish, in our very meager military establishment, we have Chinese internet connected, facial recognition cameras installed live now. My wife is half Danish, it's the same in the Danish military. I'm talking about Hikvision, same at Dahua, they're all over the place. Now that's a matter of enforcement by competent authorities in the member states. But we haven't seen that. And it's clear there that what data protection would be protecting is not only the right to privacy and data protection, but also national security. So there's many examples where the failure of enforcement is exposing Europe to serious security harms. And I just wonder, yes, I understand this point that Henrik made as well about the balance to be made, but actually there's probably a much wider area where they're complementary, and hopefully the next commission might engage with that a little bit more.
May I? Thank you for this question, because speaking about balance between two principles, we have a tendency, including me, to speak about the balance between two extremes, which is not true. It is connected. And I think that especially in light of the current security threats, the data protection field will inevitably have to work together with the security powers or entities. I will give you several examples where I believe the next commission and next commissioner will have to focus on. The commissioner dealing with data protection in relation to security. First of all, I think that we will need stronger action against the illegal spyware. There is a lot of it. We have a headache because some member states, the states are using it, in some cases abusing it against political opponents or journalists. I will not name them. You can imagine. 3 dots. But I'm finishing. I could start naming, no?
Please.
Read our rule of law report in July, and you will know who they are. But for the data protection authorities, of course, there is the issue of the illegal spyware in the private hands. This is prohibited, and it is security threat. Second, espionage, cybercrime of different kinds. Of course, the DPAs and data protection experts will be needed to disclose that. So cooperation with the secret services, for instance. Third, foreign interference of many different kinds. I will not go into details, but believe me, our enemies abroad have big fantasy how to use technology against us. We cannot afford to be much slower and less creative than them. That's why, because the abuse of technologies also contains stealing of private data and micro-targeting, which leads to brainwashing of people through very well-targeted propaganda, well, we have to at least understand what's happening, that this micro-targeting is happening. You run the process against TikTok. We do the same thing. It's about the protection of children, but you do the work about the transfers of data to China, possible transfers of data to China. Well, we need to push them to create the clouds as they promised, because to transfer the data to China means a huge security issue. Again, the work for the data protection zone. And yeah, I could continue, but there are several things where we have to say it's not that easy, that it's the conflict between one and second. Yeah, and let's use all the capacities we have for protection of privacy of people, also for helping the security side, because there is no sharp contradiction.
Do I have other questions from the audience? You're being shy? Or am I blinded by the...
They want coffee, no?
Well, if there are no further questions, I have to really thank you. It has been a really insightful discussion and hopefully a very good start for the day. There will be time to move from the appetizer to the other courses of this meal. And thanks a lot for your very insightful contribution. Thank you.